ever wondered what was in the Alaska State Constitution? Well, that makes two of us. Gotta start my timer. All right, my name's Amanda. I'm Gen X Alaska, and I'm just a nerd who wants to know everything there is to know about Alaska. So, let's begin. Dear residents of our great state, we are proud to present you with the Alaska State Constitution. This Constitution represents the diverse and unique heritage of our young state. Alaska has one of the most advanced, coherent, and forthright constitutions, allowing the people to have a clear and firm understanding of state law. All political power is inherent in the people. All government originates with the people, is founded upon their will only, and is instituted solely for the good of the people as a whole. Article 1, Section 2. With a direct and straightforward narrative, the Alaska State Constitution gives the people the power to balance the authority and responsibilities split between the three branches of government. As governor and lieutenant governor, it is our goal to ensure Alaskans enjoy what is rightfully theirs and ensure that the government remains of, for, and by the people. Alaskans are diverse in many ways, but we are unified in our admiration and commitment to this, our grand and unparalleled state. Sincerely, M.A.K.E. Dunleavy, Governor, and Nancy Dahlstrom, Lieutenant Governor. All right, then we have adopted by the Constitutional Convention, February 5th, 1956, ratified by the people of Alaska, April 24th, 1956. Became operative with the formal proclamation of statehood in January 3rd, 1959. Whew. And then it has years that it was amended. Just out of curiosity, it was amended twice in the 60s, 4 times in the 70s, 3 times in the 80s, 4 times in the 90s, once in 2004, and this says this was printed in April 2023. So that means, according to this, it has not been amended in 19 years. Okay, pretty cool. Okay. The Alaska Constitution, an introduction. In 1955, the territorial legislature passed the Constitutional Convention Act, putting in motion the election of convention delegates by district, ensuring territory-wide representation for the convention. 13 of the delegates were from Anchorage, 11 from Fairbanks, 7 from Juneau, and the remainder from 18 other communities. 55 delegates from election districts, federal judicial districts, and from the territory at large were elected by popular vote in the fall of that year. They were instructed to meet at the University of Alaska in Fairbanks, Alaska on November 8, 1955. These delegates, all Alaskans by choice or birth, had 75 days to study and write a constitutional document for the civil authority of a new state, Alaska. The hour arrived, the colors presented, and the gathering united in prayer, all as they took on this new task, crafting a document that Alaskans would have to approve by vote. It began with tedium amidst our excitement to get on to the larger issues. We had to adapt meeting times to bus schedules, agree on rules governing the convention, and acquire a gavel, all interesting tidbits of the beginnings of history. These minor concerns were soon forgotten in the wake of arguments for here's a new word, unicameralism, okay, and for bicameralism. It looks like caramel, like the candy caramel. Whether judges should be elected and how to ensure the wise use of our resources. This document is the product of Alaska pioneers, a spirit of independence and self-government. It is your guarantee that the individual will always be in charge. Surely one is moved by the simplicity and power of this document. As delegates to the 1955-56 Constitutional Convention, we each sought to create a document that was powerful and personal. Please read it and understand its continuing dedication to you as the governor, not the governed. John B. Jack Coghill, Convention Delegate, former Senator and Lieutenant Governor. Preamble. We, the people of Alaska, grateful to God and to those who founded our nation and pioneered this great land, in order to secure and transmit to succeeding generations our heritage of political, civil, and religious liberty within the Union of States, do ordain and establish this Constitution for the state of Alaska. And then it has like a little table of contents, I guess you could say. All right, here we go. Article 1, Declaration of Rights, Inherent Rights. This Constitution is dedicated to the principles that all persons have a natural right to life, liberty, the pursuit of happiness, and the enjoyment of the rewards of their own industry, that all persons are equal and entitled to equal rights, opportunities, and protection under the law, and that all persons have corresponding obligations to the people and to the state. Source of government. All political power is inherent in the people. All government originates with the people, is founded upon their will only, and is instituted solely for the good of the people as a whole. Civil rights. No person is to be denied the enjoyment of any civil or political right because of race, color, creed, sex, or national origin. The legislature shall implement this section, and that was amended in 1972. I'm curious what part they changed, and I don't know what part they changed. Did they change race? Sex? Freedom of religion. No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. Freedom of speech. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. Assembly, petition. The right of the people peaceably to assemble and to petition the government shall never be abridged. Due process. No person shall be deprived of life, liberty, or property without the due process of law. The right of all persons to fair and just treatment in the course of legislative, I can say that, and executive investigations shall not be infringed. Grand jury. No person shall be held to answer for a capital or otherwise infamous crime unless on a present mentor indictment of a grand jury, except in cases arising in the armed forces in time of war or public danger. There were some typos right there, though that wasn't my fault. There were some typos. Indictment may be waived by the accused. In that case, The prosecution shall be by information. The grand jury shall consist of at least 12 citizens, a majority of whom concurring may return an indictment. The power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. Jeopardy and self-incrimination. No person shall be put in jeopardy twice for the same offense. No person shall be compelled in any criminal proceeding to be a witness against himself. Treason. Treason against the state consists only in levying war against it, or in adhering to its enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or in confession in open court. Rights of accused. In all criminal prosecutions, the accused shall have the right to a speedy and public trial by an impartial jury of 12, except that the legislature may provide for a jury of not more than 12, no less than 6 in courts not of record. The accused is entitled to be informed of the nature and cause of the accusation, to be released on bail, except for capital offenses when the proof is evident or the presumption great, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Criminal administration. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Criminal administration shall be based upon the following: the need for protecting the public, community condemnation of the offender, the rights of victims of crimes, restitution from the offender, and the principle of reformation, amended 1994. Habeas corpus. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or actual or imminent invasion the public safety requires it. Searches and seizures. The right of the people to be secure in their persons, houses, and other property, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Prohibited state action. No bill of attainder or ex post facto law shall be passed. No law impairing the obligation of contracts, and no law making any revocable grant of special privileges or immunities shall be passed. No conviction shall work corruption of blood or forfeiture of estate. Civil suits, trial by jury. In civil cases where the amount in controversy exceeds $250, the right of trial by a jury of 12 is preserved to the same extent as it is existed at common law. The legislature may make provisions for a verdict by not less than 3/4 of the jury, and in courts not of record may provide for a jury of not less than 6 or more than 12. I'm going to continue the rest in my next video, part 2 of the Alaska State Constitution. I'm Amanda. I am Gen X Alaska. I'm just a nerd who wants to know as much as I can about my home and favorite state. And you're going to have to watch me walk by because I don't want to edit. Love ya!